Thank you for that kind introduction. My honor to be able to testify before you. I'm here to address one question. How to structure reparations in the way most likely to be upheld by the courts. My conclusion is that reparation is most likely to be upheld by the courts if it's structured in a race-neutral fashion. That is, it's most likely to be upheld by the courts if reparations are for those who were descendants of slaves rather than for all who are Black. In the United States, under current constitutional law, and in California under Proposition 209, laws that give a preference on the basis of race are either inherently suspect or perhaps per se illegal. And therefore the question is, how can reparations be structured in a way that would get through judicial review? Let me talk about two sources of law, the California Constitution and then the United States Constitution, to explain why I've come to this conclusion, then briefly respond to some of the questions that you might have about the position I'm taking, and then answer anything that you want to ask of me. The first source of law that you need to focus on is the California Constitution, what was commonly referred to as Proposition 209. It was called the California Civil Rights Initiative. It says that the state of California and all of its political subdivisions cannot discriminate or give preference on the basis of race in education, employment, or contracting. And so if reparations are given on the basis of race, that anyone who meets the definition of being Black is entitled to reparations because all have suffered from the legacy of slavery, I don't think it could survive a challenge under Proposition 209. Now, Proposition 209 is limited to education, contracting, and employment. And if the reparations were not in those areas, then Proposition 209 wouldn't be a problem. But if it's in education, or if it is in contracting, or if it is employment, then anything that is deemed as a preference on the basis of race is per se impermissible. This is different than what I'll talk about in a moment, the United States Constitution, where there is the possibility of racial preferences being constitutional. Under the California Constitution, they're not. There's relatively little case law about Proposition 209, but that which exists broadly defines what is preference. It would be hard to imagine that there'd be a reparation system that was racially defined that wouldn't run afoul of this. Now, as I said in my introduction, if this were defined as a benefit for those who are descendants of slaves, it would certainly largely overlap with race, but it would not entirely overlap with race. There are Blacks who are not descendants of slaves. There's a very small population that were enslaved that wouldn't be Blacks. So I think there'd be a strong argument based on Proposition 209 that limiting reparations to those who are descendants of slaves would not run afoul of Prop 209, whereas if this is defined in a race-based manner, then I think Proposition 209 would be a substantial problem. But assume that Proposition 209 wasn't a problem. Imagine this wasn't reparation about education, contracting, and employment, in which case it would be entirely outside the scope of Proposition 209. There is still the United States Constitution. And the Supreme Court has said now, for over 30 years, that racial classifications benefiting minorities, just like racial classifications that disadvantage minorities, are highly suspect. The Supreme Court has said that racial classifications benefiting minorities, like those disadvantaging minorities, must meet strict scrutiny. As I'm sure the Commission knows, strict scrutiny means that the government action has to be necessary to achieve a compelling government purpose. And the Supreme Court has been very restrictive as to what counts as a compelling purpose in this context. Quite relevant to your Commission, the Supreme Court has said that remedying the history of past discrimination is not a compelling purpose sufficient to justify remedial action. There was a Supreme Court case, Wygant versus Jackson Board of Education. The Jackson, Michigan school system had recently hired a number of Black teachers when it needed to have layoffs. It decided to fire white teachers with more seniority. Their argument was that this was to remedy a long history of race discrimination. They also said how important it was to provide role models for black children in the schools. The Supreme Court declared this unconstitutional, and the court's opinion was explicit that there cannot be preferences based on race on the grounds of remedying the history of discrimination. Or there's the case J. Croson versus City of Richmond. Richmond, Virginia, the capital of the old Confederacy, set aside 30% of its public works monies for minority-owned businesses. They did so because even though at that time Richmond was a city that was more than 50% black, racial minorities and blacks were receiving only about 1% of the public works contracts. But the Supreme Court declared this unconstitutional, and the court said the long history of race discrimination, including in Richmond, Virginia, didn't justify the preference that was given on the basis of race. There is now only one area where the United States Supreme Court has allowed race-conscious remedies, and that's in the area of higher education. In a series of cases, the Supreme Court has said that college universities have a compelling interest in a diverse student body, that college universities may use race as one factor among many in admissions decisions to enhance diversity to benefit minorities. This was initially articulated by Justice Lewis Powell in an opinion in Regents University of California versus Bakke in 1978. It was reaffirmed by the Supreme Court in 2003 in Grutter versus Bollinger, and then reaffirmed most frequently and recently in 2016 in Fisher versus Texas at Austin. But in the Fisher litigation, the Supreme Court made clear that college universities could use race as a factor in admission decisions only if they could prove there was no other way to achieve diversity. Now, it's worth noting that the states can do what would be thought of as protecting more rights than the U.S. Constitution, and so California can prohibit affirmative action even though it would be permissible under the U.S. Constitution. That's exactly what Proposition 209 does. But even as to this one area where racial classifications benefit minority have been allowed, the law, I think, is about to change. The Supreme Court has granted review in two cases for next October, one involving Harvard University and one involving the University of North Carolina. And the issue in those two cases is whether the Supreme Court is going to overrule the earlier decisions allowing affirmative action. Why two cases? Well, the Constitution applies only to the government. Private activities don't have to comply with the Constitution. Harvard is a private university. But Title VI of the 1964 Civil Rights Act applies to entities that receive federal funds, including private entities. Harvard obviously receives federal funds. So the issue in the Harvard case is whether or not race-conscious affirmative action in admissions violates Title VI. In the University of North Carolina case is whether it violates equal protection. It is impossible to count 5 votes on the current Supreme Court that would uphold the Harvard and the North Carolina affirmative action programs. Chief Justice John Roberts has been outspoken in his opposition to all forms of affirmative action. And parents involved in community schools for Seattle Schools No. 1, 2007, he explicitly took the position that the Constitution requires that the government be colorblind. Justice Thomas and Alito have taken the position, and with 3 additional conservative justices, Gorsuch, Kavanaugh, and Barrett, hard to imagine the Supreme Court doing anything but reversing those earlier decisions. Well, what does that mean in the context of the discussion of reparations? If reparations are framed in a race-based manner, then they would have to meet strict scrutiny, necessary to achieve a compelling purpose. And remember, the Supreme Court has said remedying a history of discrimination is not regarded by the court as a compelling government purpose. And so I think it would be very hard to convince this Supreme Court or lower courts following Supreme Court precedent that a race-based reparation program would be constitutional. I think the best hope with regard to the Supreme Court is a program that is facially race neutral, that being framed in terms of a benefit for descendants of slaves would be much more likely to be upheld. There are precedents for reparations, as this commission well knows. For example, there was the reparations provided to those who had been in Japanese internment camps. But it's important to note that that was based on people who had suffered a particular injury, and they were each given $20,000 in an apology during the Reagan administration. It wasn't anyone who was of a particular race. I think it would be hard to convince this court that a race-based program met strict scrutiny was constitutional. On the other hand, what's more encouraging to me that I cannot think of any instance where the Supreme Court has struck down a race-neutral law on the ground that it has a benefit or even a targeted benefit for minorities. As an example, some states have adopted admissions programs where they take top 10% of classes across the state. And this was undoubtedly adopted to benefit minorities, and it had the effect of benefiting minorities. And yet the Supreme Court, at least called dicta, has indicated that would be constitutional, even though the purpose, the effect would be to benefit minorities. So I come to you as the messenger. I am not defending the law as set out by the Supreme Court. It is certainly not the law as I would want it to be. And I completely understand the benefits with regard to praising reparations and framing it in terms of those who are Black. I am simply addressing the question, what is most likely to be held by the courts? Let me just respond to three things that might be in mind, and then I'll take your questions. One thing that might be in mind is there is a tremendous difficulty in proving that someone is a descendant of slaves. This will be very under-inclusive in that way. As this commission knows so well, records are incomplete. And so the cost of what I'm suggesting is that many who are deserving would not get benefits. And I think if you go in the direction of providing that those who are descendants of slaves would get reparations, how to deal with the incomplete records and the lack of documentation becomes very important. A second concern is articulated by the prior speaker, all Blacks in this country have suffered from the legacy of slavery. All should therefore be able to benefit from reparations. I think that is a compelling argument, but I don't think the United States Supreme Court would find that to be a compelling argument. If you look at the cases I mentioned, where the court says remedying the past history of discrimination is not a compelling interest, I don't see a way of persuading the current Supreme Court, that matter the lower courts, of that. And a final criticism of what I'm suggesting is that there's still the purpose of benefiting Blacks. The effect is still to benefit Blacks. Might a court not strike it down on that basis? And yes, I think that's a risk, even of a reparations law that's framed in terms of benefiting descendants of slaves, but I think it is far more likely to be upheld than a law that is framed just in terms of race. So again, wanted to address just one question for you, how to frame reparations in the way most likely to be upheld by the courts. And I'm glad to take any questions.